Good afternoon, everyone. My name is Alexis Alvarez. I'm the Director of Statewide Training at Florida Legal Services. Thank you all for joining us today on this Friday. And before I keep going, I'm going to put on the closed captions. I always get started and forget to do that immediately. Closed captions are on. Thank you very much for joining us today on this Friday. I love trainings. I love meeting with you all on Friday, but the thing I love the most is talking about criminal law, especially when I get to talk about it in the context of how it affects your practice as housing attorneys and folks that work in the legal aid sphere. So I'm really excited about today's training, not because you all are here only, not because of the content only, but also we have an awesome lineup of speakers to talk to you about the intersection of housing barriers and the criminal legal system. Before we move into introductions of those speakers and the content that we have here today, I want to make a few housekeeping announcements. First and foremost, the closed captions are on. I just turned them on for you all. So if you need that extra accessibility, please feel free to press show captions. If you have any issues, just message me and I'll help onboard you. Second piece of housekeeping announcements. We would like to hear from you. Submit your questions through the Q&A. We have 1, 2, 3, 4 people on here who are going to work to filter your questions as they come up. So don't be shy. If you're looking at a slide or hearing something that is being taught and you want to know more, pop your question into the Q&A. We will answer that as quickly as possible. Third piece of housekeeping announcements. This is going to be CLE credit approved through the Florida Bar. We're still pending that CLE credit, but I do expect to receive that. Knowing my luck, it'll be right when we get off of here today. Certainly by next week, I expect to have our CLE credit, and I will email you all that code as soon as I receive it. And with that, I do want to give a little shout out. The Public Interest Law section of the Florida Bar is co-sponsoring this along with our statewide training initiative. PILS is an awesome organization. Think about joining it, joining to be around folks who are like-minded, who do the awesome work that you do, to have sounding boards and community, which we all know that we need. Final piece of housekeeping announcements. This is being recorded, and a copy of the recording will be sent to you all within 24 hours via Zoom. Obviously, if you don't get that recording, you can reach out to me directly. I will drop my email into the chat. So enough of the boring stuff. I'm very excited to introduce who we have here today. It's an awesome collaboration between the Florida Rights Restoration Coalition and the National Housing Law Project, two just giants in these fields. So thank you to both of your organizations for being here. With the Florida Rights Restoration Coalition, we have Neil Volz, who is Deputy Director. We have Katherine Williams, who is the Policy and Legislative Manager. Let me get to my fancy slide that has everyone's names. And from the National Housing Law Project, we have Natalie Maxwell, who is a managing attorney, and Sarah Brendan, who is a fellow with their organization. So I wasn't lying to you. We've got a great lineup here for you, great content, great speakers. The floor is yours. Thank you all for being here to teach us about this important subject and for all that you do in the community.
Thanks, Alexis. So we're going to start off with a poll so that we can get a sense of who is joining us for the webinar today.
And I'm going to launch that poll. Give me 1 second. Poll launched. Can you all see it? Perfect. Seeing some responses coming in. Who's on today's webinar? And Natalie, just let me know when you want me to either share the results or take it down.
Does it look like there are still responses coming in?
We've got a few. We've got about 27 in. Let's wait till we get a few more minutes. Wait till we get to that 30 mark. 85% have participated. Thank you all for participating. And I think with that, we can close it. And to share the results, we have an overwhelming amount of legal aid attorneys.
Fantastic. Looks like we also have a few paralegals joining us today. So thank you all. And then Alexis, if you can go back to the previous slide. So for today's webinar, we're going to cram in a lot of information for you all. We're going to start off with an overview of when criminal record screening practices can be can constitute housing discrimination. Next, we will get into the main housing stages where the issue can arise. So admissions barriers that are imposed by housing providers, as well as evictions and lease non-renewals. And then we will move into crime-free housing programs and nuisance ordinances. And we will leave you all at the end with best practices around these policies and procedures. And we will leave some time at the end for questions. But as Alexis noted, if you have questions as we're going through, because there's going to be a lot of information provided today, you can go ahead and pop those into the Q&A. And with that, we can move on to our second poll. It's going to be our last poll for today's webinar. And that is to get a sense of what folks already know about the intersection of the criminal legal system and its impact on housing access. So the poll question is, what types of interactions with the criminal legal system impact housing access? And you can select as many responses as you want. And we'll give folks some time here to respond. So the options include calls to 911, juvenile records, arrests, convictions, probation, sealed records. And when we say sealed records, what we mean are records that where the public won't have access through government databases, but city, county, state, and federal government agencies will still have a legal right to access those records. And that's different than expunged records, because when a record is expunged, that means that agencies that would have had access to the sealed record will still be able to know that the criminal information has been expunged. And then the last two options are all of the above or none of the above.
And we have about 58 folks who have participated. I'd give it a few more minutes, see if we can get to that, 80%, 70, 80%. Thank you all for participating.
All right, how's it looking?
Looking good. We're at 77%. So I'm going to end the poll, everyone. Thank you for participating, and I will share the results.
Okay, so we got a wide variety of responses here, which says that this webinar is going to be really informative to folks. So to not leave you in suspense, there is a correct answer to the poll, and it is that all of these types of interactions can impact housing. So with the rest of our time, we're going to start showing you how and why that is.
There we go. Did we shift to the next slide?
Yes.
Perfect.
Thanks. So one thing we want to talk about is just the sheer scale of this issue. And so one thing we mentioned is that 1 in 3 people in the US has a criminal record. Also, 1 in 2 children have a parent with a record. So when we talk about families and households and access to housing, that is a really key piece. Another thing is that formerly incarcerated people are 10 times more likely to experience homelessness than the general population. So this is a really vulnerable population. We see within that there are marginalized groups even within this group. So people who experience racial disparities, people who might have a disability. And for every 1 formerly incarcerated person who is experiencing homelessness, 3 are housing insecure. And so access to kind of stable housing is a significant barrier. And we can go to the next slide. Thank you. And we're really going to dig into this more, but what these barriers look like. I think one of the thorniest parts with housing is we have kind of general barriers that everyone might experience, affordability, just sheer supply of housing, but then people with records experience these really unique barriers to both private and subsidized housing. And we're really going to dig into those. Neil, did you have anything you wanted to add?
Yeah, just a couple things. One, but thanks, Kate. So one, I'm a person with a past conviction, and understand kind of the how those barriers present themselves in your life. And I think when we're talking about housing, we are talking about something that's very deep and very important to kind of how community works, how families work together. You know, the ability to reduce recidivism, the ability to create, a more flourishing community, all combines in this space of housing. So it's a really broad, deep issue, like you mentioned, Kate. But especially for those of us with convictions and arrest records, the barriers can really kind of come at you from a variety of different perspectives. And so we're just trying to put a little bit of a face on kind of this topic of conversation. And I saw who's there. I'm grateful for all the legal aid workers and folks who are in it. Thank you for what you do on behalf of people. But just last thing I would say is just kind of recentering this a little bit on the families and the individuals who are struggling because of the barriers that exist to housing.
So I'm going to kind of move us into a discussion of some of the legal frameworks that you can use and that become involved when there's housing discrimination based on a conviction record or an arrest record or an incarceration history. As Neil and Katherine were just saying, this impacts millions of people across the country, and it also can have a disproportionate impact on a number of marginalized groups. I think the previous slides touched on race and disability. And so based on some of the laws that exist and the other legal frameworks, discrimination based on a criminal record can actually constitute discrimination based on a different protected class or unprotected class as well. We can go to the next slide. Thank you. So beginning at the federal level with HUD, this is kind of a wordy slide that has a bunch of different guidance documents that HUD's put out over the last few years. And HUD recognizes that screening out someone based on a record can be discriminatory. So all of these touch on that in somewhat different ways, but also very similar ways. And they essentially outline what to do and what not to do when you're screening people with conviction and arrest records as a landlord or a property manager or a public housing authority. So if you do go back to these slides later and want to read all of these in depth, these hyperlinks on here go to each individual guidance documents, but some kind of high level things to note for right now. The PIH notices, the first notice and the last notice, apply only to public housing authorities and owners in project-based rental assistance properties. So that's not landlords who accept Section 8 housing choice vouchers. However, the 2016 and 2022 guidance documents applies to all housing that's covered under the Fair Housing Act. And we'll talk about that in a second, much broader. So it's both subsidized housing and housing on the private rental market. And there are descriptions on the slides of what kind of each covers, but a lot of them flag discriminatory practices like screening people out using arrest records. That's kind of a known issue that HUD has discussed a number of times, is very likely to be discriminatory, really frowned upon. Also using blanket bans, so a policy where a landlord will deny housing to anyone with any type of conviction over any number of years, no matter how old the record is, for instance. Things that are really broad, that's also seen as highly discriminatory by HUD. And then they also kind of promote using processes like individualized assessments, so giving an applicant an opportunity to contextualize what the record means, what the circumstances were, to speak to someone one-on-one. A lot of times if you're in the admission setting, someone's applying for housing, this might be algorithm based, and a tenant screening tool is generating a score. So slowing that process down and giving people the chance to speak is often a big part of individualized assessments, and then providing mitigating evidence on a case-by-case basis as well. So again, these documents can be very useful. Advocates will use them in situations where an applicant is denied housing or denied a subsidy to HUD to kind of appeal that denial. And we can go to the next slide. So that is the guidance that exists from HUD currently. There is some new HUD work coming down the pike, I think, as people say, sorry. And this is because HUD has been conducting a review of their own policies that create barriers to housing for people with records. So there's been this long review going on. And as part of that effort, they're going to be doing a new rulemaking next year to strengthen all of this guidance and hopefully come out with additional protections and additional information for landlords and property managers to follow. So this screenshot on here is an announcement that HUD released that previews some of the areas that the rule is going to cover. We don't know everything, but they have sort of flagged automatic denials and blanket bans, targeted screening, and individualized assessments and evidence and mitigation. So a lot of the things we talked about on the previous slide, but it will remain to be seen what exactly is covered in the rule. It's likely going to come out probably sometime early spring of next year. So stay tuned. And we definitely encourage participating in that. There will be a public comment period once the rule comes out. So having advocates share their stories or share tenant stories and tenants also share their experience can be really, really impactful, even something very short. So just a little plug for participating in that if you see it come through. Next slide, please. So I mentioned that the guidance documents that HUD relies on touch on or are based on the Fair Housing Act, I think. But we're going to get a little more into how the Fair Housing Act can actually be used to combat denials or other discrimination that somebody with a record might encounter. This slide lists the 7 protected classes under the Federal Fair Housing Act. So states can have more than this, but this is the federal floor. And so as I was saying, HUD's guidance is kind of based on the fact that the Fair Housing Act prohibits discrimination based on race, and criminal records are highly racialized. However, race is not the only protected class that kind of a criminal history might implicate. So if we go to the next slide, we have some kind of bolded categories that can often come up in a situation where someone's looking at a conviction record or an arrest record based on housing. Just to touch on a couple of them, disabilities, people with disabilities are really overrepresented in both prisons and jails. And so the failure to include something like an individualized assessment is often a really big deal if you're looking at someone's record and there's a history of disability in some way. And that can definitely constitute disability discrimination. And then sex has this kind of little parenthetical. And this is because the Fair Housing Act does not explicitly name domestic violence survivors as a protected class, but because the vast majority of survivors are female in this framework, discrimination against someone who's a survivor of domestic violence or other violence can constitute sex discrimination if that person also has a criminal record. And we'll touch on this a little bit more. Also, we're going to talk about VAWA, the Violence Against Women Act, but it does show up in the Fair Housing Act a bit as well. We can go to the next slide. Thanks. So we talked about who is protected under the Fair Housing Act. Just a quick review of some of the key actions that are prohibited under the Fair Housing Act. This is definitely not an exhaustive list, but it's some of the things that can show up, especially in this housing application admission setting where a person with a record is trying to access housing. So if you go through the list, a lot of kind of refusing to rent to somebody based on a protected class. It also includes making advertisements that are discriminatory or harassment or discouraging rental. There's also the refusal to make reasonable accommodations or to permit a reasonable accommodation if someone's going to pay for it. And just in case anyone's not familiar, reasonable accommodations are changes to rules, policies, practices, or services that would be necessary to allow someone with a disability the equal opportunity to enjoy the dwelling or a public space on the property or the unit that they're applying for. So all of these things can constitute a Fair Housing Act violation. Next slide. And so to actually bring a claim for a Fair Housing Act violation, there are a couple of different theories of liability: disparate treatment and discriminatory effects. If you kind of suspect there's a Fair Housing Act violation going on, we do suggest that if you're like working with tenants or someone applying to housing and you might want to bring a claim, you definitely reach out to a local fair housing center because these cases can be kind of resource intensive. And so they have a lot of experience and just expertise around bringing these. But the idea behind the next few slides is just to kind of give a high level overview of what these two theories of liability cover and where they might show up more often. Next slide. Great. So the first one is disparate treatment, and this is what most people think of when they think about discrimination. It's essentially treating somebody differently because they're a member of a protected class, and it's intentional. So it's a really key difference between these two types of liability. And this is also where fair housing centers can be really powerful. This is often what, if you've heard of fair housing testing, a fair housing center will send out, for instance, one white tester and one black tester to apply for the same unit with the exact same conviction history, let's say. And if the landlord or the property manager who they speak with flat out denies the black tester and says, sorry, our policy doesn't allow this, we can't offer you the unit. But then they tell the white tester, oh, I understand you have this history, but we can work something out. Possibly they're a lot more flexible. That can be evidence that there's, written policy that's the same, but it's being applied differently and point to intentional discrimination based on race. So really, really helpful for a disparate treatment claim to have fair housing testing, but it can also just be evidence that, a property manager, somebody who someone spoke with said something outright discriminatory. The idea is that you're pointing to direct or to intentional discrimination based on a protected class. And we can go to the next slide. Discriminatory effects, by contrast, does not require showing that discrimination is intentional. It's the idea that you can have kind of a facially neutral policy or a practice, but even if it's applied without the intent to discriminate, it causes discrimination based on a protected class. And discriminatory effects liability is kind of an umbrella. Underneath, you have disparate impact and perpetuation of segregation, which are described in brief on these slides. So I'm not going to get too into detail into these today. Disparate impact theory has a lot of steps. It's a whole process, but I do think it's important to note that there is a 3-step burden shifting framework to bring a disparate impact claim. And HUD has a discriminatory effects rule that outlines these 3 steps. And there was a rule from 2013 that first established it that was challenged a lot in the courts, but there is a latest kind of rule out, that's the 2023 rule, which reinstates the 2013 rule. So this 3-step burden shifting framework, if you look it up, is the latest and greatest. There was also a challenge in court that officially upheld that 2023 rule in federal district court. So that is kind of where we are at with disparate impact. It can get a little bit confusing if you look all the way back at the history. And then also just to note that perpetuation of segregation is something that's more commonly seen in kind of governmental entity context, maybe zoning. And so it's not as typical of a theory of liability for maybe an individual housing admissions case, but important to know nonetheless. And so finally, in this section, the last sort of statutory protection we'll touch on is the Violence Against Women Act, or VAWA. And this is a really important protection for people applying to housing or living in housing who have any kind of interaction with the criminal legal system, because it protects survivors from denials or from evictions, from like any adverse actions for criminal records that are related to their status as survivors. So it can include, anything that has to do with someone's experience as a domestic violence survivor. If they then something happened and that resulted in a record with the system. Landlords, owners, PHAs can't deny someone housing or take adverse action based on that record. And this also, just to note, this isn't really like for today's topic, but it does extend pretty broadly even beyond conviction records to include something like a low credit score from economic abuse. So VAWA is a very, very important and powerful tool for survivors. You can go to the next slide. This is a screenshot with all the different types of covered housing. I don't know if I mentioned it explicitly, apologies, but the Fair Housing Act applies to basically all housing. There are some exemptions and exceptions, but it's not just subsidized housing. It includes private market housing. VAWA applies to a really wide array of subsidized housing, but does not apply to private market rate housing. So only federally assisted housing and homelessness programs are included. And this screenshot is from the VAWA 2022 reauthorization. So it actually expanded some of that covered properties a little more. So if you need to, double check if somewhere that a tenant is living is covered, you can go to the 2022 reauthorization and there's this list. And another really important thing to note about the VAWA reauthorization is that there's a new section 603, which is the right to report. And the reauthorization protects tenants and others' rights to make calls to police or other emergency services from their home. So I think this came up in the polling question that calls to 911 can be used in housing discrimination. And we'll touch on it a little bit later when we talk about crime-free programs and nuisance ordinances. But penalizing a tenant or a tenant on behalf of a guest in their home for calls to police or calls to 911 is a pretty common issue. And in VAWA covered housing, that's explicitly protected and prohibited. Landlords can't take adverse actions, can't evict because somebody has been making calls to emergency services from their home. So I think I'm going to pass it back to Natalie to talk about some of the admissions barriers.
Thanks, Sarah. And I just want to highlight, Sarah mentioned, that the right to report crime is new, and in case, I just want to underscore in case people miss it, because this is a VAWA protection that really applies to anybody, so not just to survivors. So it protects landlords, it protects homeowners, it protects guests, and so that's a change that may be a little bit confusing because it's contained within the VAWA statute. So with that, I will move on to talking about kind of the first piece in the housing journey where we see people experiencing housing barriers, and that is with applying for housing. And so in terms of admissions barriers, the first thing that I'm going to talk about are overly restrictive admissions policies. So next slide. And when we talk about these restrictive admissions policies, I'm referring to policies both for in the private rental market as well as the subsidized or assisted housing market. And I just so that I don't confuse people, I have a tendency to go back and forth between subsidized housing, or using the phrase subsidized housing, and federally assisted housing. Just I am talking about the same exact type of housing. So just want to make that clear. So in terms of there's really three broad categories of overly restrictive admissions policies that folks encounter. So the first is blanket bans, which Sarah touched on earlier, in which a housing provider just denies admission to anybody with a conviction, regardless of the nature of the conviction, the amount of time that's passed since the conviction, or any other factor that's related to whether that individual applicant actually poses some sort of safety risk or threat. The second category of admissions bans that we tend to see are unreasonable screening criteria. So these can be things like screening for criminal activity that has no bearing on a person's success as a tenant. So the example that I always give, because I used to see it all the time as a public defender, was people who had arrests or convictions for shoplifting at the Walmart and now were being denied access to housing. So, the connection there, like there's just no connection there in terms of someone's ability to be, a tenant or to rent someplace. Other non-conviction records that sometimes get pulled into this application process might be things like arrests, juvenile records, which I know is surprising to folks. And as I touched on with the poll, even expunged records, particularly in Florida, where we have at least, for now, we have very broad government sunshine laws and public records laws. And so there's just a lot of information that's available. And just because someone's record is sealed or expunged does not mean that the information for the underlying conviction or arrest cannot be found, because we have all of these databases and information available. And then the third category of restrictive admissions policies involve the look back periods. So this is screening for criminal activity that goes back for a very long time. So as a legal aid attorney, the example I give is that I had a client who had applied to live in senior housing, so like senior HUD subsidized housing, and he was denied because he had a criminal record. and the admissions person told him to reapply in 60 days because his conviction would no longer be covered by their admissions policy look back period at that point. And the admissions policy for that particular property included a 10-year look back period. So just like ludicrous, that just an example of how that clearly has no relationship to whether or not someone can be admitted as a tenant if it's something as arbitrary as having to wait 60 days to apply. We can go to the next slide. So in addition to the overly restrictive policies I just covered, for the federal housing programs, there are some mandatory as well as discretionary admissions bans. So we're going to start by looking at the mandatory admission bans. And where there is a mandatory admissions policy, what that means is that the housing provider has to deny the person admission to housing. And I'll touch on a very few exceptions, but just know that these are denials that are in federal law. And so the first one that I have here on the slide is anyone who's been convicted of manufacturing meth on federally assisted property. So in that case, the admissions ban applies to both public housing as well as the Housing Choice Voucher Program. HUD operates some other housing programs, one of which Sarah mentioned, their project-based rental assistance program. So this ban does not apply in that context. And the other kind of main subsidized housing program that you may encounter operated by USDA is the Section 515 program. And so it doesn't, this admissions ban doesn't apply in that program either. In other words, the owners that are participating in project-based rental assistance or the 515 program have discretion to decide whether to include that in their admissions policy as a mandatory admissions ban. So the second policy that's incorporated into the law is anyone subject to a lifetime registration for a sex offense is prohibited from admission into federal housing programs. And that actually applies across all 4 of the housing programs that I described. So the public housing program, the Housing Choice Voucher Program, the project-based rental assistance program, as well as USDA's 515 program. And then the third mandatory admissions policy that creates a ban for housing applies to current users of illegal drugs, abusers of alcohol, or someone with a pattern of drug use or alcohol abuse that interferes with the health, safety, or peaceful enjoyment. That ban also applies across those programs. So one thing that I will note that's not on this slide that you have not heard us mention is the low-income housing tax credit program. And that's because that program does not have any mandatory admissions bans related to criminal history, which is really important because that is the main program that's used to build new affordable housing in communities. And we can go to the next slide. And then the final mandatory admissions ban that I'll touch on is anyone who has been evicted from federally assisted housing for a drug-related criminal activity within the last 3 years. And for this one, however, the rule does give PHAs or the covered housing provider, so it's not just PHAs, some discretion in that they can admit a household if the person who had engaged in the drug-related criminal activity has completed a supervised drug rehab program, or there's been a change in circumstances. And specifically, the examples given in the rule are where the person has died or is incarcerated. We can go to the next slide. All right, so here's an example of what I'm talking about. So this is an admissions policy from the Gainesville Housing Authority. So I'm going to pick on GHA kind of throughout the presentation, in part because their policy is available online, so it's easy to access. And they have examples of several of the admissions and evictions policies that we're going to touch on. So the things I want to highlight about this policy is that the HUD rule has a 3-year look back period for drug-related criminal activity, but the Gainesville Housing Authority has opted to impose a 5-year look back period for drug-related criminal activity. With regard to the exception around if someone has participated in a drug rehab program, the PHA here has decided that it has to be a rehab program that they have approved. And then finally, the changed circumstances that are included in this particular policy are where the person who committed the crime is no longer part of the household. So that could be very broad. We can go to the next slide. And then in terms of some discretionary admissions policies that are used by subsidized housing providers, I want to make a few notes. So what that means is these policies are not required by law. So they do not have to have these policies. And to the extent that you are, dealing with a housing provider, a federally assisted housing provider that has these policies, there really is an opportunity for advocacy, which our friends at FRC are going to talk about in a little bit. Also, the definitions around the type of criminal activity is language that was created by HUD. So these are not our definitions. And as Sarah mentioned earlier, HUD has undertaken a review of these policies in recognition that they create barriers to housing for people with records and also have civil rights implications. So the kind of admissions discretionary policies that you're going to see are related to drug-related criminal activity. That could include the manufacturing, sale, distribution, use, or even possession. It's going to cover violent criminal activity, which the rule defines as the use of or threatened use of physical force that will cause serious bodily injury or property damage. And then there's a catch-all provision around criminal activity or other criminal activity. And this is really focused on any criminal activity that threatens the health, safety, or right to peaceful enjoyment of residents, of people nearby, or the property management staff or other folks that are engaged in the property. So we can go to the next slide. That discretion is not unlimited. And so it is subject to some very important limits. And one of those is time. So there is in the statute some language that states that the criminal activity restrictions have to, or the policy has to deal with criminal activity that has occurred during a reasonable time before the screening takes place. And in addition, as Sarah touched on, there are limitations under the Violence Against Women Act. If the housing provider has to consider if there are any adverse factors. And then finally, there are an array of civil rights laws, including the Fair Housing Act that Sarah touched on, which also provide additional limits on what those discretionary policies can look like. And I want to note, because we keep talking about both subsidized housing and private market housing, that the restrictions around time and VAWA apply to the federal programs only, whereas these civil rights laws broadly apply to both private market housing as well as the subsidized housing. And so going on to the next slide, we have another sample from GHA in terms of their admissions policy. So this is part of their discretionary policy, and they deny admission for current drug use, which they have chosen to define as illegal drug use in the prior 12 months. So if you'll recall that the statutory language discusses that it has to be a reasonable time, but here you see that the PHA has decided that the reasonable time is 12 months. Also, this is a policy where they consider both arrests and convictions in making admissions decisions. And as Sarah noted before, there's a lot of guidance out from HUD about how problematic arrest records are. So I'll just let people sit with that. And however, they do have some language in here that convictions are given more weight than arrests. And then in terms of mitigating factors, and they list that they include information that's provided by service providers that are working with household members. And we can go to the next slide, and I will turn it over to our friends at FRC to talk about some of the advocacy strategies for addressing these admissions barriers.
Awesome. Thank you so much, Natalie. And I'm cognizant of the time, so I'll try and be brief, but I think as we shift into a little bit of a conversation around advocacy, it might be helpful to get a understanding of kind of where FRC is coming from, generally speaking, in terms of how we advocate. We're kind of best known as an organization for passing Amendment 4, which restored voting rights for about 1.5 million Floridians with past convictions. And since then, we have continued to work and kind of with this new growing constituency, those of us who have past convictions, those of us who are in our communities trying to take those past problems and turn them into purpose through advocacy. We really see patterns, right, that lead us to our priorities. And it really revolves around breaking down barriers so that people can live a better life with their families and their communities, and that we believe our work actually helps everyone involved. That we know that when people get access to housing, for instance, that what we're doing is helping people get access to housing on its front end. But what we're also doing is improving the community for everybody by walking through that process. We know that lower recidivism rates occur when people are able to access housing. We know that that leads to less crime in the future, less expenditures needed in that area. And so that really can be a win-win for folks. And in fact, we did 10,000 surveys of returning citizens in the state of Florida and asked us, what are our top priorities in your real life? What are the kind of things you'd like to advocate for? What kind of change would improve your family's life? And access to housing, access to employment, access to opportunity, top of the line, every time, everywhere, in every part of the state of Florida. So please know that, because when I realize I'm on the Zoom call with a bunch of fantastic legal minds who are trying to help improve the community, I think advocates. So I'm hoping y'all are step away from this call wanting to engage in this type of advocacy, because it can change lives. So when we think about the HUD programs here in Florida, some of the work that we've done, well, one, you talk about Gainesville, right? Thank you for that, Natalie. That was very informative. It reminds me that this kind of work, especially here in Florida, we're like walking in a Dickens novel, right? It's the best of times and the worst of times. Because the truth is, we've been working in Gainesville with some local leaders to change second chance employment policies in Gainesville, and have seen real progress. In some ways, there's a pattern there where we're trying to reduce barriers so that people can be treated like anyone else, despite having some interaction with the criminal legal system. And so on the one hand, I know that Gainesville is moving forward in that area because we've been involved in that. And then to see some of the challenges in housing, that's like just even sitting here, like as an advocate, like, oh gosh, we need to engage this. But it reminds me of some of the changes we've seen just up the road from Gainesville in Ocala, where we've seen local housing authority professionals take advantage of the second chance voucher program that came online. So they've created a whole new line of vouchers in the community specifically for people who have been impacted by the criminal legal system. We've been there. They have wraparound services and a local nonprofit that helps facilitate this process. And you're seeing this win-win play out in a local community here in Florida, in which we all know, like, if people have access to housing, then that helps in terms of finding employment, reconnecting with your social network, moving forward with your life in a positive way. And so that type of advocacy can have a real impact. And if anybody's interested, the folks over at the Ocala Housing Authority are welcome. They welcome phone calls, and they can speak to that better than I can, for sure, in terms of how those specifics work. Again, trying to be cognizant of the time. Kate, do you want to discuss a little bit about kind of the private landlord piece and some of the advocacy that we're working on in that space?
Yeah, great. So what we see for private landlords especially is one option is locally passed fair chance housing ordinances. And we really see the barriers to that kind of change. You know, imposing those restrictions is one way to think about it on private landlords. In Florida, especially, that is challenging. And we also worry about things like state preemption. We've seen that happen with other local level housing reforms in Florida. And so for us, in terms of advocating in this kind of landscape and really trying to change things for private landlords and for the people that we serve, is state level landlord liability legislation. We've seen, and Neil just highlighted it, like these barriers to employment and housing, we can really learn from both. And in employment, the number one reason that employers screen past criminal records is to reduce liability. It's not to ensure a safe working environment or because they're worried about some criminal activity happening. They're worried about their legal liability. And so we see more and more states applying that same kind of, addressing that same kind of concern in the housing space. And so for us, a really key takeaway is that Texas and Tennessee, both in the past few years, have passed legislation and successfully implemented landlord liability protections for renting to people with past criminal records. And like Neil said, we really view that as a win-win. It takes away a risk for landlords. And again, we're talking about 1 in 3 people have a record. And so for landlords, it removes the risk and gives them more freedom to make choices about their property. And then for people who might have a past record, it helps remove just helpfully one of those barriers to housing. So that's something that we are working to introduce in the Florida legislature this year, is a piece of legislation that would take that same approach and apply it to Florida. And we can go to the next slide.
All right, so the other phase in the housing process where we see these issues come up is around evictions and lease non-renewals. Next slide, please. And particularly what we see is the one strike policies in public housing. And these policies are remnants of the war on drugs. So many public housing agencies adopted a tough on crime sentiment. And this is especially true when it comes to drug-related criminal activity. So where these policies are in place, tenants can be evicted for any criminal activity, even the criminal activity of guests of which they have no knowledge. And HUD still allows these policies, but as you have heard, they are undertaking a review of these policies. So you might see these policies adopted in other types of housing as well. Next slide. And so our friends in Gainesville, in their policy, have allowed for lease terminations for activity that is both on or off the premises by any member of the tenant's household or guest, just so you can see like how wide an impact these policies have. And they define a pattern of drug use as more than one incident of drug use in the prior 6 months. Next slide. And so in terms of advocacy strategies for challenging these laws, it's the same things that you have heard Neil and Kate talk about. As attorneys, we always have the ability to litigate, but litigation takes time. And in the eviction context, sometimes we end up having to litigate it because you're representing a client who's brought into eviction court. So just don't forget to raise these issues as defenses in these cases. And Neil or Kate, did you want to add anything to that? Okay. And then the last thing that I'll say on that is that there are also just a number of local and state planning processes where advocates can impact eviction policies, particularly with PHAs and their PHA planning process, as well as with the obligations of PHAs and jurisdictions to affirmatively further fair housing. And as we've talked about, these types of policies really are contrary to promoting fair housing in communities. Next slide. I'll turn it back over to Sarah.
Thank you. I'm struggling to come off mute there, sorry. So we wanted to also address, I mentioned this earlier, some policies that can kind of impact both admissions and evictions of people who have records, crime-free programs, and housing nuisance ordinances. They're often spoken about together as like crime-free nuisance work, but they are sort of slightly different from each other and do slightly different things. So crime-free programs are typically targeted at like training landlords, creating these kinds of safety first is how they'll be talked about, housing programs that ultimately work to control landlord behavior and will penalize them for any tenants on their properties that commit some kind of quote criminal activity.
As Sarah was saying, it penalizes landlords for tenants that commit criminal activity at the property. That can be, they generally include mandatory criminal background checks of tenants or applicants, mandatory landlord trainings around how to enforce these policies. Participation in these programs might be mandatory or voluntary, and they typically require property owners to execute a crime-free lease addendum with the tenant. And then the other program, which is the nuisance property ordinances, with these ordinances, they generally have a broad definition of what constitutes nuisance conduct. The allegations of nuisance behavior obligate the landlord to abate the nuisance or evict the entire household. And they subject the owner to potential fines, fees, condemnation, or loss of a rental property license. So these programs are generally designed and implemented by jurisdictions, typically cities or counties, and both control the behavior of property owners and harm tenants and families. Next slide. And important to our work is that these programs really reinforce Jim Crow effects, particularly in the South, in that they give police unchecked discretion to reinforce racial boundaries and target Black and Brown communities for eviction and displacement. And they permit oftentimes white neighbors to directly control the behavior of their neighbors of color by threatening their housing stability if they don't behave in a way that's considered acceptable. So these policies result in evictions that destabilize communities of color and make it increasingly difficult for them to secure new housing for the reasons that we've discussed. Next slide. So a number of Central Florida communities adopted crime-free housing programs over the last couple of decades. Some of those programs have been repealed, as is the case in Orlando and Orange County. Tampa's program was under investigation by the Department of Justice for race discrimination. And Kissimmee had a program, although I'm not sure of the current status of the program. But here is a copy of a crime-free lease addendum that I acquired through a public records request. And it's an example of what I was talking about in the earlier slide, and that the lease addendum that's typically executed, it's endorsed by the police department. Can I go to the next slide? It has a non-exclusive list of criminal activity that can serve as good cause for eviction. And it notes that conviction is not required to serve as a basis for an eviction. And finally, most disturbingly, is that it contains a provision that if it if this lease addendum conflicts with the lease, then the crime-free lease addendum controls, which is particularly problematic for subsidized housing properties since that conflicts with their obligations under federal law. Next slide. And so both HUD and DOJ have been engaged in a number of activities to limit the use of these programs. So in 2020, HUD reached a voluntary compliance agreement with the city of Hemet in California, resolving allegations that the city's crime-free rental housing and abatement of chronic nuisance programs violated Title VI of the Civil Rights Act of 1964. Next slide. In 2022, the Department of Justice finalized a consent decree repealing the crime-free housing program in Hesperia, California, and the accompanying ordinance, and established a victim fund. In the lawsuit that DOJ filed, they allege that the city of Hesperia and the San Bernardino County Sheriff's Department engaged in a pattern or practice of discrimination against Black and Latinx individuals and communities in violation of the Fair Housing Act and Title VI of the Civil Rights Act through the adoption and enforcement of their crime-free rental housing program. And in fact, the facts there, one of the city council members said on the record that they had a demographic problem, referring to the increase in the Black and Latinx population in the community. And then the last one I want to highlight, next slide, please, is an action that happened or an announcement last month where DOJ issued a letter of findings against a city in Minnesota, finding that their crime-free housing program violated the Americans with Disabilities Act and the Fair Housing Act because it denied tenants with mental health disabilities equal opportunity to receive emergency assistance. Next slide. So some advocacy strategies around here, and I'll turn it back over to my friends at FRC.
Thank you. So yeah, I'm just going to briefly talk through what we saw in Orange County, and then Neil will talk through Hillsborough. And so one of the things we want to highlight with these programs is they can include some more kind of sinister practices and then ones that are fine. And so one of the things that we saw when we started talking about the word, the phrase eliminating crime-free housing is one, there was some opposition because why would you want to eliminate something crime-free, right? And so that's where we really started to get into conversations around, okay, how can we reform these policies to make them less harmful? Because one of the things I really want to highlight is for some of these lease addendums, they can say suspected criminal activity or criminal justice involvement. So even things like a call to the police because someone is experiencing domestic violence can result in these, and Natalie really hit on it, like these are automatic triggers in some cases that a tenant or a household will be evicted. And another kind of key harmful part of this program is in many cases, landlords were then required to, or the sheriff's, participating sheriff's department were automatically required to notify all participating properties when a tenant was arrested or had some kind of interaction with the criminal legal system. So the household would experience eviction, and then also if they went to another participating property, that property would have already been notified of their recent involvement and they would be barred from securing housing there too. And we've seen, for instance, in Orange County and other places in Florida, we're talking many different properties collectively representing thousands of housing units participating in these programs. And so in Orange County, we really focused on how can we reform this policy. And we worked with the sheriff's office to successfully take away the kind of automatic supplying of arrest information, the lease addendum and mandatory eviction, and it just focused on another kind of less discussed part of these programs, which is crime prevention through environmental design. So landlords usually, in addition to being required to have the lease addendum to do these evictions, they also are required to do certain property improvements, lighting, signage, maintaining their property and ensuring certain security measures. And so in Orange County, we really focus on how can we kind of reform and strip down their crime-free housing program to just deal with those environmental design issues. It's still a way for property managers to signal to prospective tenants and to current tenants that they care about safety and they're taking active steps without some of these harmful practices. And Neil, I'll turn it over to you to talk about Hillsborough.
Awesome. And I'm seeing the time here. So I in Hillsborough was a little bit of a different experience for us because the effort was really being driven by some legal professionals, the local newspaper, and community advocates. So we were alongside some of our partner organizations as that campaign really developed in a little bit of a different way. It was built around gathering data and proving the disparate impact that those policies were having on the Black community in Tampa, and ultimately saw a movement come out in terms of changing the crime-free housing policies in a positive way, but not necessarily eliminate. They came up with a new name, and so there's a more complicated story. But the advocacy work was also like we were a little bit more of a partner, helping to push on the ground as you had wonderful scholars and journalists digging in to see what the data shared, and the data told a really nasty story of what was happening to people's lives in those communities in Tampa, and it forced the mayor to move along with the pressure from the community. So those are the kind of efforts, and we are here on a Zoom call like this. If people, contact us, let us know, what's going on across the state. We try. We are more. We're a statewide organization, but we have a lot more presence in some areas of the state than others. But we're dedicated to this mission, and it's been really, really cool to spend some time with everybody here on this call. If we can go
And
to
then
the
Neil, you want to jump into best practices?
Yeah, if we can go on to the next slide. Yes, when we look at best practices for non-discriminatory practices, I think it's important to understand that what we're talking about here really are like guideposts, right? I look at the first one there. It says, don't screen for criminal history at all, right? A guidepost. I know that Seattle is a city that has really stretched themselves and leaned into policy change that will dramatically improve lives for people in the city of Seattle, kind of based on this idea. But even their solution includes, some acknowledgement and nuance within that in certain parameters and certain circumstances, there is some sort of background screening that's going to take place. And I think that's the biggest piece that I walk away from when we start talking about these kind of practices, is that really that we need to have the guideposts. We need to know what our shared values are and how do we push forward in those best practices, but to also understand that these are negotiations and conversations within community, and that even many of those, the best steps that we've seen do include, some sort of kind of more nuanced conversation. So I can even hand it back to you, Kate, if you want to dig into any of those a little bit more specifically.
Yeah, I just wanted to kind of give some clarity to no look back periods, because I know even when I first read that, I think, well, you have to look, if you're going to look back at all, you have to look back some amount, right? But what we're really talking about here, and what we've seen when trying to reform these policies, whether in housing or employment, is sometimes shorter look back periods are put forward. And because they're shorter, rather than like the 10-year example we talked about earlier, maybe it's 3 years, maybe it's 5 years, that is used kind of as a guide to have a broader ranging scope in terms of the types of records that are looked at. So for instance, we see for the Orlando Housing Authority, any criminal record from the past 5 years can be grounds for denying someone public housing. We don't want to see any look back period that broadly applied, honestly, no matter how long or short it is, because we don't want to create a barrier for people, especially when their record has nothing to do with their kind of suitability as a tenant. And so what we've seen often is, whether it's a shorter or longer look back period, it usually people feel that that gives them license to apply a really kind of broad lens in terms of the types of records that they're looking at, including sealed or expunged records, arrest records, et cetera. And so we advocate for there to be no kind of look back period that really allows that to happen, that you're really only looking at a narrow set of records that are relevant, and that you are especially considering those mitigating circumstances, which can include time elapsed, but also things like someone's efforts at rehabilitation. And one thing I wanted to note, and then we'll turn it over for questions, is a lot of these best practices overlap with the same kind of model that we see for second chance employment. And we have across the country seen more progress in people doing kind of fair chance, second chance employment policy as opposed to housing. But the point is, we can really learn from what cities and counties, even your cities and counties, are doing in the employment space, and that might give you a good model for what's possible, or at least an approach that people are familiar with when it comes to housing reform. So if we want to go to the next slide, we can take any questions.
Awesome. Thank you all so much. This might be one of my favorite trainings that we've done at the statewide training initiative. The way that you blended practical knowledge and frontline advocacy, policy reform, it was just really, really awesome. I didn't see any questions that came in through the chat or the Q&A. I wrote down 3 that I had, and I had a comment. Do you all have the time for that? I know we're after 1 o'clock.
Alexis, if we could go through, there's a couple slides here with kind of how people can get involved
Yes.
With the information, and then I definitely have the time to stay on and answer your questions.
Awesome. So let's do that. I switched over to the first slide. Tell me how to continue with the slides.
Okay, I can jump in here. We're really grateful for the time and the topic to talk this through with experts in the field. If anybody is interested in some pro bono opportunities with the Florida Rights Restoration Coalition, we've got 2 that we want to just share with you. Obviously, you can read what's going on here, but as it relates to people who are impacted by Amendment 4 that passed in 2018. If you remember, we passed the initiative. All of us, went to bed that night thinking that, hey, 1.5 million people are going to get their voting rights restored. And what we've seen was the implementing legislation that was passed by the legislature says that you have to pay your financial obligation, your fines, fees, anything that was ordered by the judge before you're eligible to vote. So they're waiting. They're hoping to figure out a way to get to be able to vote, to have their ability to vote fully restored. And so what we've been working with is in the judicial districts all across the state, and this is really coming online just in recent months, and we're starting to see a lot of progress, is that we're able to work with local courts to modify people's sentences from, hey, you owe $700 in fines and fees that you've had for 11 years and you can't figure out how to pay it because you're putting food on the table. You can actually change that to community service, right? Or you can eliminate it entirely. We actually have had some judges who have done that. But that process does take the skill set of people who work in the courts. And that's why specifically we're asking folks on this call, like, hey, if this is something, if you want to help give somebody the gift of, get their vote back, this is a great opportunity to do it because the system is actually set up to help people this way. And we're learning how to do it. So that's one. And you can email nicholas@floridarrc.org for that. And I'll be real quick on the next one if somebody wants to. And this is, we also have a Florida Legal Services Department in which we're helping those individuals who have been arrested for voting. If there was a slew of arrests in 2022 for people who thought they were eligible and got a voting card from the state, but the state made a determination that they were voting illegally and arrested dozens of them. And so we wanted to make sure that anybody could have access to legal counsel if they, or they could stay with the public defender if obviously that's what they wanted, but we wanted them to know they had an opportunity, and then we worked to get people out on bail. And so Stephen is our lead on that. If that's an area of work that y'all do and you want to dig in a little further, it's Stephen@floridarrc.org. So thank you for allowing us to kind of plug those opportunities to serve in the community and help somebody out. Both of our systems are running pretty smoothly at this point, so I think it's relatively simple for somebody to get plugged in.
Awesome. Thank you so much, Neil. And with that, If anyone has to hop off, totally understand. Anyone that can stay on, that's including our hosts, our panelists, and the audience. I had one comment and a couple of questions. I think maybe I'll start with my comment, just because I'm really jazzed up about this conversation. And this whole conversation that we've had here today has also made me think about the other flow, right? So we're looking at the criminal conviction barriers to housing. But as a former public defender, I remember so many times that there were folks living in subsidized housing that I felt, I can say this, I don't really work against HUD or anyone like that, that were really targeted, that really were taken out of their housing opportunities because they were in subsidized housing and experienced criminal, intersection, which makes me think of when we're talking about the responsibility for guests that you have in your home, and how much easier it is to get kicked out of your subsidized housing because you have a guest that may have done something that if you aren't somebody that has to rely on subsidized housing, you wouldn't be in that position, which then filters that continued cycle of criminalization and homelessness. And I just really wanted to make that comment and open it up if anybody did want to comment on that. But this whole time I was thinking, gosh, everything is just so unbelievably connected. And so with that, I did have 3 more practical questions. The first question being on accessibility barriers that we discussed. So I know, as we talked about, people living in subsidized housing are responsible for actions and criminalization or criminal activities of their guests. Does that also include their juveniles, their children or juveniles that are living with them? Can they also be, evicted or taken out of their housing because of someone's juvenile criminal activity?
Yes, it's just to jump in real quick, if it's any member of the household has criminal involvement.
And so then the second question I had is when we're looking at the screening process, I imagine at times people might be in subsidized housing and been accepted based on a particular screening application, but then maybe in the next year they've changed or tweaked something to the screening application that might lead to that person no longer being eligible for that housing. How does that work? It's a kind of an ex post facto question, but how would that work if I'm somebody that has been living in subsidized housing? Now the screening process has changed. Can I be kicked out based on a new screening assessment?
So I just want to make a comment about the juvenile records, and then I'll answer that question. So if you are dealing with a situation where there is some threat to housing based on juvenile records, one concern to raise and investigate is how the housing provider found out, because those records are not public records like adult records. And so that generally will lead to some other perhaps larger impact issues in practices that are going on in your community. And then in terms of the admissions criteria, so if you are currently in a subsidized housing program, you don't get rescreened if the admissions criteria changes.
Okay.
And if there are any changes in terms of basis for non-renewal of a lease or an eviction, folks should get notified of that when they go to renew their leases and have an opportunity to challenge that, particularly if it's around one of the subsidized housing programs, with the exception of the Section 8 voucher program, because the other programs have kind of clear policies and where in terms of what steps the housing provider has to take if they're going to change those types of documents.
Awesome. So actually, I only had 2 questions. Those were my 2 questions that I had. And in the meantime, I didn't see anybody else drop any questions into the Q&A. But as I give those closing remarks, if anybody does want to drop anything in the Q&A, please feel free. We'll answer them until we sign off. Thank you very much for answering my questions and this awesome presentation. I hope it really excited everybody, on this watching this presentation to continue, identifying the ways you can, help your housing clients or clients experiencing housing issues, and empowering you to not be afraid of assisting folks that have criminal convictions through this, very important process. Securing housing is one of the most important things that anyone can do. So all of you that work in this sphere are just incredible warriors, helping people that really need it. And so quick reminder, the CLE credit will be emailed to you all once I receive it. I have all of your names, all of your email addresses, don't worry. I did drop my email address into the chat. It's all the way at the top. So if anybody wants to check up on the CLE credit or has any follow-up questions, please feel free to email me directly and I will get you the information that you need. I don't think there's really any other housekeeping other than also reminding you all that this was being recorded. It is being recorded, and you will all receive a copy of this recording within 24 hours of today's event. But if you don't see that in your inbox, you can always reach out to me directly. And so, Sarah, Natalie, Neil, Katherine, thank you very much for your time. Any last remarks before we sign off for the day? Awesome. Well, you all are amazing. There are thank yous coming into the chat. Have a great Friday, a great weekend. And again, thank you for today and everything that you do for our community.
Thank you.
Thanks, everyone.
Bye.